How to patent an idea in the UK. In this video, we will explain what a patent is, how much it costs, and walk through the simple steps to patent your idea. If you are interested in other ways of protecting an idea, see our link in the description. This guide has been put together by the product development team at Innovate Design. Since 2001, Innovate Design has drafted thousands of patents, many of which have been granted in the UK, the US, and around the world. We specialise in helping inventors and startups to commercialise their new ideas. We wrote this guide specifically with them in mind. So firstly, what is a patent? A granted patent provides legal ownership of an invention, which offers a number of benefits we'll discuss in this video. The Intellectual Property Office, or IPO, is the government body that oversees patents in the UK. The IPO says it grants patents for inventions that meet these three criteria. The first requirement is that it must be new, so it can't be something that already exists. If you mention the idea publicly, it may be considered in the public domain, and therefore no longer a new invention by the time you decide to protect it. For this reason, we recommend you keep your invention a secret until you have applied for your patent. Only disclose it to others under a non-disclosure agreement or NDA. An NDA would legally prevent those who have entered into the agreement with you from disclosing the invention to others. You can download a copy of our free NDA template by following the link in the description. The second requirement for a patent is that it must be inventive, not just an obvious modification to something that already exists. This means if it is obvious to someone skilled in the area of your invention, it is probably not patentable. The final requirement for a patent is that it must be something that can be made or used. For example, you can't patent the idea of chopping potatoes, but you could patent how a machine that chops potatoes actually works. The criteria in other countries may differ, particularly in terms of what can and cannot be patented. There are 4 parts to a patent application. 1. The abstract. This is a short synopsis of the patent application. 2. The description. This is the detailed explanation of how the invention works, including background information relating to other relevant patents. 3. Figures. These are annotated line drawings of your invention to support the wording of the patent. 4. The claims. Your claims regarding what is unique about your invention. This is the most important part of the application and will be used to decide whether your patent will be granted. Why would you want a patent? Well, there are 4 main reasons. The first reason for a patent is that it can help you make money from your idea. You can use a patent to agree on a licensing deal where another company pays you money to use your invention. These are called royalties. You can also sell the ownership of your patent. Secondly, patents can deter people from stealing your idea. Stating you have a granted patent, or even that you are patent pending, lets people know if they try to steal your invention, you may be able to prevent this. Don't forget, there are no patent police rounding up people who have stolen inventions and sending them to patent prison. It is up to the owner to sue the suspected thief in court and settle the matter themselves. The third benefit to a patent is that it can help to defend against people who might try to sue you. If someone tries to claim your product uses their invention, you could choose to countersue them and argue that, in fact, they are using your invention. The fourth and final reason to patent your invention is that patents can make your business more valuable. Protecting your invention with patents can increase the value of your business should you wish to find investment to develop your product or when the time comes to sell the business. So, patents can be a really valuable way to protect your invention. But how do you get one? It's worth mentioning that before you actually apply for your patent, we often recommend a worldwide patent search to try and find out whether your idea is actually new. We talk more about patent searches in a link in the video description. Remember, you can't patent what the idea does, you can patent how it does it. So next, you need to develop the design, and for that we recommend you use design professionals like us. Professional designers can help you add detail to the invention which will add value to your patent. They will likely use 3D CAD software to produce a 3D model of the design, which can be used by a patent lawyer to add images to your patent application. Find out more about designing your product by following the link in the description. When your design is ready, you can apply for a patent. Although you can do this yourself, Innovate's unique approach to design and patents can help you create a broad application with reduced upfront cost. So, in summary, a patent provides legal ownership of an invention. The Intellectual Property Office is a government body which oversees patents in the UK. They only grant patents for inventions that are not already in the public domain, so keep your idea secret with a non-disclosure agreement. The invention must not be obvious, and it must be something that can be made or used. There are 4 parts to a patent: the abstract, description, figures, and the most important bit, the claims. A patent can help you make money from your idea. They can deter others from stealing your idea. They can help you countersue those who might say you stole their idea. And owning patents can make your business more valuable. To obtain a patent for your invention, we recommend starting with a worldwide patent search to see what's already out there. Then develop the design, and finally, you can apply for a patent. But how do you get one? First step. File your patent. After your patent application is filed, the Intellectual Property Office will issue you a receipt of the application, and the date on it is known as your filing date. This allows you to claim you have a patent pending over your invention and is the date you will claim ownership from. Next, you need to pay official fees. Within 12 months of the filing date, you will need to pay a filing fee, request a search, and pay the search fee, which at the time of making this video adds up to between £130 and £250. Within roughly 6 months of requesting a search, the UK Intellectual Property Office (IPO) will issue you a report of their findings from previous patent applications and other public documents. The IPO will also need to conduct an examination of your application and will issue a report detailing any objections. If there are objections, you can choose whether to abandon the application or make amendments for the IPO to re-examine. It's publication time. After 18 months, your application will be published, and after a bit more back and forth, you get your results. Next, it's results time. If your application was successful, the patent is then published as granted. Congratulations, you now own a UK patent. The IPO say it typically costs £4,000 to grant a patent with a patent attorney, and typically takes 2 to 4 years, but other strategies are possible. You may wish to consider patenting the idea in other countries, for example where the product would be manufactured or sold. To do this, you must apply for patents in other countries within a year of your filing date. A patent can last up to 20 years if you pay the yearly renewal fees. And that's it! You now know the basics of how to patent an idea. So to summarise, the patent process generally goes like this. First, file your patent. Then pay official fees, and the IPO will detail any objections to your application, which you can respond to with amendments. After 18 months, your application will be published, and a bit more back and forth, you get your results. If your application was successful, you now have a granted patent. It typically costs £4,000 and takes 2 to 4 years with a patent attorney, but other strategies are possible. You can apply for your patent to protect your invention in other countries, and patents can last up to 20 years. We hope you enjoyed this video and found it useful. It is part of a series of free short courses we created all about developing and protecting new product ideas. If you're interested in learning more, click the link in the video description. Thanks for watching.